How are you?
I'm fine, sir. I'm in new campus.
Oh, very good.
How are you, sir?
I'm fine. Welcome, Mr. Shivank.
Good morning, sir.
Good morning, brother. I hope everything is fine.
Yes, I hope
Yeah.
everything is fine on your side as well.
I should wait for another 1 minute. Let others join. Where are you, Mr. Shivank, right now?
Sir, I'm in Delhi only,
Where?
but I'm not in hostel. I will be shifting maybe this week.
Okay, okay.
Yeah.
Yeah. Let us get down to business now. Once again, I formally welcome you all. This is the, in a formal sense, last engagement in a semester of LLM. It has been a long journey, and I hope all of us have enriched each other. But in higher education, my dear friends, there is no full stop. There are only different stages of our evolution. We have completed three most mature stages of our educational, intellectual, juridical evolution. And now we are going to enter into or going to attain the fourth stage. And at this particular stage, as a part of a regular advanced degree, we collectively be in a better position to evolve further. in terms of juridical, intellectual, teleological, and epistemological understandings, approaches, ideas, connotations, conflation, combination, and understanding the different dimensions and their delineations in the area of international refugee law. Therefore, I formally once again welcome you all, and I hope it is going to be the most fruitful extension of our journey, and we are going to enlighten each other. My dear friends, international refugee law over the years has attained its independent status. It has evolved itself as a part of international law to a new independent separate discipline. However, I should not underestimate the cascading impact of international law and other important specialized branches of international law. And therefore, this is a requirement that we should attach and we should adopt an interdisciplinary approach in understanding various dimensions of international refugee law. Currently, if you take into account the global picture of refugees, you will find that there are as many as more than 100 million refugees worldwide. 1.4 million refugees are there. For the sake of understanding, we generally address them as refugees. But if you take into account the intra-fragmentation of different classes of the people who happen to be on the move, there are people who have been displaced from their roots. There are people who have lost their sense of belongingness. There are people who migrated because of economic reasons. There are people who are fleeing because of the well-founded fear of being persecuted in their country of origin. There are asylum seekers. There are internally displaced persons. There are climatically displaced persons. There are forced displaced persons. There are war refugees, whom I address as humanitarian refugees. There are people who started their journey from their country of origin to the country of reception as ordinary citizens, but having landed in the country of reception, they have become refugees. There are armed deserters who seek refugee status. There are people who do not have any kind of a state. They are generally addressed as stateless persons or stateless people. So host of what we call of refugees, I mean, in a better understanding, in the understanding of the journalistic language, there are many facets of refugees. Before I engage you in the very first week in a formal sense, my dear friends, I have already emailed you the course structure, and that course structure should be before you. People in this area, this is a very sensitive, specialized, and immaculate area of research called international refugee law. As an ordinary citizens, my dear friends, all of us are having our rights, our fundamental human freedoms, our fundamental human rights. Our rights have been guaranteed under our respective constitutions. In case of violations of any kind of rights, we generally come out for the redressal, restoration, and reparation of all kinds of violations, individual violations, collective violations, denial of the collective rights, deprivation of individual rights. Everything is possible in the ordinary circumstances in our respective geopolitical entities. But in case of refugees, asylum seekers, migrants, stateless, internally displaced persons, forced displaced persons, climatically displaced persons, and other kinds of refugees, or the people who happen to be on the move in their own country from one place to another, or the people who happen to be on the move by crossing an international border. This class of people requires a special attention. That is why international refugee law came into existence. There is a history of what we call the population movements. Before I take you to the anthropological and geographical dimensions of the movement of population, I would like at this stage to provide and to acquaint you with certain important legal frameworks. These legal frameworks are going to be the inalienable companion of our engagement in the area of international refugee law. I have some of the important texts I have already shared with all of you, but that is not sufficient, what I have already shared. It is the tip of the iceberg. My dear friends, as a part of legal framework, as a part of our research program, as a part of our intellectual understanding of international refugee law, we require all the human rights treaties which you have studied in your third semester. I would not be naming what I have already submitted as a part of the third semester in the class of international human rights law. But at this stage, my dear friends, what is important is that you should understand certain important specific subject matters in the form of legal frameworks, in the form of declarations, international declarations, in the form of regional declarations, in the form of specific national legislations. My dear friends, subject matter or the legal framework of international refugee law is based on 1951 UN Convention relating to the status of refugees, 1967 UN Additional Protocol to the UN Convention relating to the status of refugees, Universal Declaration of Human Rights of 1948, particularly Article 13, 14, 15, 1967 Territorial Asylum Declaration. 2018 Global Compacts on Refugees and Global Compact on Migrants. Under the mandate of 2016 New York Declarations on Refugees and Migrants. And before that, after 2016 New York Declaration, there is another important declaration that is known as the Baku Declaration of 2017. There is another declaration, my dear friends, for the regional purposes, and that was adopted by the organizations of American states. That is a declaration that was adopted at Los Angeles, and that is popularly known as the 2022 Declaration on Migration. This is going to be, in a formal sense, and very limitedly speaking, our subject matter in the area of international refugee law. But these frameworks are highly inadequate frameworks, limited frameworks. These frameworks do not constitute a complete subject matter of international refugee law. There are some specific articles, my dear friends, in the Civil and Political Covenants of the United Nations of 1966. There are specific articles relevant to the refugees in the UN Covenant on Social, Economic, and Cultural Rights. We have to consult even 1948 United Nations Convention on Genocide. We have to understand other important conventions like a Torture Convention, Migrants Conventions, and many other international human rights treaties. As a part of international refugee law, my dear friends, there are certain specific movies as well. These movies are also available on YouTube, but I have identified, after cajoling and visiting the entire gamut of movies, I have selected a few important videos for your perusal, for your screening, which are definitely going to serve the fundamental needs in understanding different aspects of refugees. Even the latest movie that is calling the shots and very prominently in the international circles. And my recommendation would be that you must see this movie, which is available on YouTube, The Swimmers. Whenever you find time, see this movie. Another important aspect which I would like to bring to your perusal is the national jurisprudence that has been developed by the various Supreme Courts in South Asia as well as beyond South Asia on refugees. That is going to be the part of our engagement. There are different aspects. Number one aspect is there are some specific refugee crises at a global level, which requires our attention because of their peculiarity, because of their uniqueness, because of their distinct characteristics. In our vicinity, my dear friends, in South Asia, not only in our vicinity, but even in South Asia, we are having a refugee crisis called Rohingya refugee crisis. We are also having other refugee crises as well. In Europe, we are also having a refugee crisis. Sometimes the crisis of refugees in Europe, sometimes it is addressed as, refugee crisis of Europe. That we would be dealing with subsequently. Syrian refugee crisis, Afghan refugee crisis, Venezuelan refugee crisis, Mexican refugees crisis, Roma minorities as refugees, and to what extent they can get some kind of a refugee status. That is another important, question. And above all, my dear friends, there is a unique refugee crisis for which even prior to the incorporation of 1951 Convention, there has been an arrangement, a legal architecture of an administrative character was created by the community of nation states, which is known as a Palestinian refugee crisis. In 2022, we also came to know and confronted with another important, refugee crisis, that is the Ukrainian refugee crisis. My dear friends, there are so many refugee crises, but we have been, witnessing deprivation, denial, demonization, dehumanization, and discrimination in these, crises, refugee crisis. Global North nation states, in some crises, they have been directly linked. Some refugee crises have been created because of their policies. Some refugee crises, they were created because of their indirect involvement. And some of the refugee crises have been directly created by them. And therefore, my dear friends, we have been witnessing xenophobia, racism, fascism, and Nazism in these refugee crises. Military or armed forces of a geopolitical entity are directly involved, and they have created these, refugees. Military junta of Myanmar, Russian armed forces, involvement in Ukraine, IS, they have also created a lot of, refugees. Gulf War I and Gulf War II have, created a lot of, refugees in the Middle East and Far East. Destabilizations of the democratically elected governments in various geopolitical entities have also created refugees. Interference in the internal affairs of the global South, economies and geopolitical entities by the global North, sovereignties have also resulted in the creation or generation of, refugees. Development is another important, area that has also created and made people refugees. In the name of, technological advancements, in the name of development of the geopolitical entities, In many what you call, nationalities, you will find, in many homelands, you will find, in many, nation states, you will find that the people have been displaced, uprooted. There is another dimension to it, that the climate change. Climate change is another important nemesis that has come there to stay and to make this planet highly inhospitable for human existence. Even climate change has also created a specific class of refugees, which is today known as climate refugees. So what is the role of the nation states? How these refugees and their sensibilities and sensitivities are going to be addressed or have been addressed. And my dear friends, this is the reason why a new kind of a reception of refugee argument is emerging at international level. Because the idea, to a very limited extent, the idea of the durable solutions already failed. We have failed it. And that is why the private sponsorship of refugees in many geopolitical entities have been emerging for long, particularly in the post-2015 era, when for the first time European powers confronted with the Syrian refugee crisis, when for the first time in the month of March in 2015, a civil war, broke out in Syria, and that made people refugees, and they headed towards the, European nation states by crossing the inhospitable Mediterranean Sea. So that is the, whole picture. And this picture, my dear friends, has presented certain important, pertinent, and tricky questions as well. And these are the questions which we are supposed to address, my dear friends. In this particular week, I'm not going to make a presentation of the overview of the course structure. I am directly beginning, my dear friends, the week first, what we call, engagement. Before formally taking you in engaging in the area of international refugee law, it is equally important to understand that there are different kinds of terms and terminologies of international refugee law and forced migration studies. This should be understood, because we have to understand the global population movements, forced migration. We have to understand the magnitude of the forced protection, the forced migration, as well as the idea of international protection. The protections which are available to the ordinary citizens in their geopolitical entities are not available to refugees. That is why we have to understand, my dear friends, that specifically we have to understand what are the unique requirements of the refugees for their survival. We have to understand the role of the media on reporting refugees and their issues, how these issues have been assessed by the media, examined and analyzed. We have to understand the public attitudes, opinions and perceptions on migration. And we have to provide some kind of a reconsideration and re-evaluation of these kinds of what we call of, attitudes. And therefore, my dear friends, Or let me put it like this in the words of the, Hannah Arendt. Hannah Arendt of, France. She has devoted and exclusively written a treatise which is known as Of Totalitarianism. She was of the view that the right to asylum, despite its long and sacred history, was considered to be in conflict with the international rights of the nation state. But why, and why do states commit to protecting foreigners today? My dear friends, states constitute the primary nexus when it comes to security for individuals and groups. And at the same time, the principal threat to the human security, and that principal threat, my dear friends, has got some kind of a transnational character. Therefore, there is a question: is the opposite is true for refugees and asylum seekers? With the transnational globalization expanding, our state is still the primary nexus of security for individuals? What difference does border crossing make to the international community, or international communities, what we call humanitarian obligations, and why? Because under international refugee law, my dear friends, the refugee status is a privileged category vis-a-vis other classes of forced migrants. Then in such a context, my dear friends, another question arises. And the question is, my dear friends, what other classes are there and do they require international protection? Therefore, it becomes necessary, my dear friends, how can we solve the refugee problem? Is there any kind of a possibility to have a refugee-free world? If you take into account my understanding in this context, I am of the view refugees are going to be there and they are going to be coterminous with the existence of humanity on this beautiful planet. We cannot have a refugee-free world. But it is important. Rather, I would like to address a different question. And the question is, how can we improve protection of refugees, asylum seekers, migrants, and stateless people fleeing their country? And how can we help refugees resume their normal life in the country of reception, in the country of reintegration, in the country of what we call of, nationality? And we also require, my dear friends, that there has to be some kind of an agency at international level. That is why we are having United Nations High Commissioner for Refugees to supervise and ensure that the respective nation states respective protection of refugees. If I cite my recent blog, my dear friends, in that blog I have submitted, and that is a very ambitious what we call suggestion on my part. And I hope no nation state, no geopolitical entity is going to concede to that very suggestion. Right to compensation, right to reparation of the nation states, or the refugee receiving nation states or refugee hosting nation state from the refugee generating state. I don't see any kind of a possibility on the part of community of nation states. There would never be any kind of a possibility or consensus on this particular right, which I have argued recently. So there are certain important questions. Why study international refugee law and forced migration, and why do people move, and where do they go, and why, and why, where did people move? And many other important, questions are also, there. So therefore, it is important, my dear friends, when we take into account the solutions of the refugees or refugee problems, then we should understand certain important aspects. Aspects, as I have already submitted, aspects relating to terms and terminologies. Number one is assimilation. What do we mean by assimilation? My dear friends, assimilation means adaptation of one ethnic or social group, usually a minority, to another. Or in other words, let me put it like this: assimilation involves the subsuming of language, traditions, values, morals, and behavior, or even fundamental vital interests and values. There is another important term, asylum. These terms we are going to use in our daily interactions, daily engagement in the area of international refugee law. Asylum means a kind of a grant by a state of protection on its territory to persons who are fleeing persecution, serious or irreparable harm, or for other reasons defined in the national law. National law includes constitution as well. For example, I can further elucidate it. My dear friends, asylum encompasses a variety of elements, including protection against non-refoulement and permission to remain on the territory of its asylum country, possibly with a view to local integration. The 1951 UN Convention relating to the status of refugees, supplemented by international human rights law, lay down the standards of treatment to which refugees are entitled in the country of asylum. There is another important term, non-refoulement. My dear friends, spelling wise this term, and let me make it very clear. This word, which is written as non-refoulement, but this is not the correct pronunciation of this word. This is a word which has been taken from the French literature, from the French protection laws. Therefore, English people are also pronouncing this particular word as per the French pronunciation. And the French pronunciation of this word is non-refoulement. Non-refoulement means non-expulsion, no forced deportation, no forced return. That is the meaning in English. This particular term, my dear friends, has been incorporated under Article 31, subclause 1 of 1951 Convention relating to the status of refugees. So this expression is going to be the part of our engagement. And in the days ahead, on numerous occasions, I am going to use this particular term. So it should be clear in your mind that this is the meaning, this is the import, this is the etiological understanding of this particular expression called a non-refoulement. Under Article 3 of the Torture Convention, you have already studied in your international human rights classes as well as in your personal capacity. That Article 3 of the Torture Convention of 1984 also uses the word, non-refoulement. though it has not been in its current visage, it has not been what you call located in the torture convention. But instead of non-refoulement, the word expulsion has been utilized or used. It is equally applicable in case of what we call in 1948 Convention on Genocide. So these expressions constitute a very, very important understanding, particularly in enhancing and evaluating and delineating different dynamics and dimensions of international refugee law. Another word that comes to my mind is asylum seeker. Apart from asylum, there is another word, asylum seeker. Asylum seeker is a person, my dear friend, who seeks safety from persecution or serious harm in a country other than his or her own, and awaits a decision on the application for refugee status under relevant international and national instruments, legal instruments. For example, somebody who is fleeing Myanmar or Pakistan just to avoid his or her persecution only on the ground of political opinion, sex, membership of a particular social group, or the grounds of persecutions which have been provided in the definition clause under Article 1 of 1951 Convention relating to the status of refugees. So in case of a negative decision, my dear friends, the person must leave the country and maybe expelled as may any non-national in an irregular or unlawful what you call situation, unless permission to stay is provided on humanitarian or other related grounds. So asylum seeker is another important terminology. Another word which we are going to use in our interactions in the class of international refugee law is country of origin. What do we mean by country of origin? Country of origin, my dear friends, means country where an asylum seeker, refugee, or migrant comes from, and of which she or he possesses the nationality. In case of a stateless person, the country where he or she has his or her habitual residence in a given situation or given time. There is another word which is known as the detention. As a part of what you call of a civil society, my dear friends, you have been studying magazines and newspapers, where you are coming across with this kind of a terminology called a detention. Detention means a deprivation of freedom of movement, usually through enforced confinement. If you take into account Article 31 of 1951 Convention relating to the status of refugees, under this article, it has been provided that certain safeguards in relation to restrictions of freedom of movement for refugees who enter or reside in the country illegally. United Nations High Commissioner for Refugees Executive Committee, conclusion number 44 comes to my mind, where you will find that certain important standards have been contemplated which are applicable in these kinds of situations of detention. There is another important term which we are going to use during our engagements in this class, and that is durable solutions. My dear friends, durable solutions, the means by which the situation of refugees can be satisfactorily or permanently resolved to enable them to live normal lives. This generally involves voluntary repatriation to the country of origin. Voluntary repatriation. Voluntary repatriation, I am emphasizing this particular point because in the Samyuddha's decision delivered by the Apex Court of India, this was the contention which was not judicially satisfied. And that is why I argued and critiqued this decision. Therefore, voluntary repatriation. But majority of the situations you will find that the national governments have developed a habit of repatriating refugees without ensuring the voluntariness. This is the condition number one under the entire trajectory of durable solutions. It demands that repatriation under all circumstances be voluntary. I will also evaluate an agreement between Afghanistan and Pakistan of 1993 exclusively on voluntary repatriation. And we have to ensure, we have to locate the voluntariness of any kind of repatriation of refugees. That is durable solution number one. The second durable solution that has been provided under this trajectory involves, my dear friends, local integration. Local integration, including natural or through naturalization, you may call it. If somebody has migrated and fled his or her country of origin because of a well-founded fear of being persecuted, then after serving and fulfilling all the citizenship conditions in the country of reception, there is a possibility of his or her local integration in the country of reception. And the third important durable solution that comes to my mind is, as a part of this durable solution trajectory, is resettlement in a third country. Resettlement in a third country, that option is available to refugees, but in majority of the situations, the national governments or the governments of reception have violated this particular fundamental principle of their in resettlement. In the week 7 or 8, when I am going to take up the regional what you call protection of refugees, I would be giving you a detailed treatment of this particular aspect. In case of the European nation states refugee policies, laws and frameworks, there is another important what you call term, which is known as expulsion. Expulsion is synonymous with the idea of what you call non-refoulement. But expulsion is generally considered, my dear friends, as an act by a state authority with the intention and the effect of securing the removal of a non-national from its territory. Refugees lawfully on the territory of the state can only be expelled for reasons of the national security and public order. This is an argument, my dear friends. National security and public order. This is an argument which is generally undertaken by majority of the national governments. And these national governments, my dear friends, take this argument because of one particular clause in the 1951 UN Convention relating to the status of refugees, and that is Article 31, subclause 2. But it has been seen, and this is my personal understanding. In my individual understanding and assessment, I am of the view in majority of the situations, these two important narratives have been invoked by the national governments exclusively on the basis of their subjectivity or subjective understanding of a particular situation. And this element of subjectivity is based on either religion, majoritarian narrative, or far right what we call policies of a geopolitical entity. Because we have to understand the religious character of, of refugees. We have to understand the racial, what you call, import, the racial characteristics which are generally attributed to a particular refugee group. Rohingya refugees, for example, they are not only refugees, my dear friends, but at the same time, they are a minority in Myanmar. So this should be understood in the larger, what you call, perspective. Another example from South Asia we can give from India. CAA/NRC controversy is still, fresh in your mind. How the, citizenship legislation, how that legislation has been amended by the Indian Parliament. On a personal note, in my individual capacity, my dear friends, as a student of, international refugee law, I do not have any problem with this, amendment in the citizenship legislation in India. Because this is the right kind of a step that has been taken by the government of the day, but it is not the full measure or the full step. It lacks something. It is a religion-based, what we call, amendment. And my contention is, one religion has been left, and that, religion is Islam. Therefore, the religion of Islam must have been, included. Because country like, Pakistan, there are, some minorities even among the Muslims. There are, some minorities on the basis of their Muslim sect. In South Asia, as a member, nation state of the SAARC grouping, Pakistan remains a Muslim majority nation state. It is a fact. But there are, there are, Muslim races who are in minority. My friend from Pakistan, Miss Wasif Rasool, will further, what he call, elaborate and further, enlighten me. But my dear friends, it is equally important to understand these, dimensions. That there are, Shias. There are, other groups. There are, Hazaras, Pashtuns, Tajiks, Uzbeks, Qadianis. They are also, they are also subjected and they are targeted. And lot of persecution is taking place. So if they have to move out of, Pakistan, that India is not a choice for them. I know one of my, friends. She recently got the Belgian, citizenship. In 2016, when I visited Oxford University in a conference, I met her. And over there, we befriended as a colleague, and still we are exchanging lot of, academic and research related ideas. She was, subjected to torture by the government of, Pakistan and law enforcement agencies of Pakistan. Particularly since her husband happens to be a journalist. So because of the, his reporting and on the basis of his, political opinion, he was hounded by the law enforcement agencies. So one day they have decided to leave Pakistan and they fled. First, she got asylum in Belgium, and now she has also got citizenship. Recently, she got. So even if you are living in a Muslim majority nation state in South Asia, or you are living in a Buddhist majority state in South Asia, even if you are living in a Hindu majority nation state in South Asia, even then on the basis of some considerations, you may be persecuted or likely to be persecuted. And that is the beauty, my dear friends. The word persecution has not been defined under international refugee law or under international human rights law. I will come to that subsequently when I am going to discuss definition of a refugee. Right now, it is not my what you call, priority to discuss persecution or the grounds of persecution, but I will let you know how many grounds are there in the definition clause and how the word, definition or the what should be the definition, because there is no consensus even on definition who is a refugee. Volumes and volumes of, books are there in the public domain, not on refugee law, not on persecution, only on the issue of who is a refugee. Voluminous, treatises. So it's a vast area, my dear friends, and we would be. Even I have also tried a definition of refugee in my PhD thesis. Long back, almost 20 years back, I did try to have a definition of refugee as a student of international, as a research scholar, or as a student of international refugee law. So this is very, very difficult, and therefore, as a part of our terminological understandings, I am simply undertaking this idea of what we call of expulsion. Another important word that comes to my mind is the forced displacement or the forced migration. My dear friends, compelled or coerced departure of a person from his or her home or country due to certain important examples. Suppose, for example, I can say due to a risk of persecution or other form of serious or irreparable harm. Such risks can exist due to armed conflict, serious disturbances of public order, natural disasters, the inability or unwillingness of a state to protect the human rights of its citizens. That could be the what we call Another important terminology, that is internally displaced persons. Internally displaced persons or group of persons who have been forced or obliged to flee or to leave their homes or places of habitual residence, in particular as a result of, or in other words, or in order to avoid the effects of the armed conflict, situations of generalized violence, violations of the human rights, or natural or human-made disasters, and who have not what we call crossed an international recognized border. They are generally known as internally displaced persons. But my dear friends, we do not have any kind of a specific law on internally displaced persons. Now the question arises, though I have given a separate what we call week, so far our deliberations are concerned on internally displaced persons, I would be deliberating and discussing at a later stage, but for the sake of understanding, because these terminologies, terms and expressions are important to begin this particular engagement on international refugee law, so that you should feel comfortable what kind of a terminology, what kind of a nomenclature are coming and emerging during our interactions. So when we are talking of internally displaced persons, we do not have any kind of a treaty on that. There is no international convention to address the problems and the rights of the internally displaced persons. As of now, internally displaced persons are generally dealt with under 1998 United Nations Guidelines on Internal Displacement. It's a soft law in the form of principles. Some normative considerations have been provided to the nation states at international level. In situations of internal displacement, this should be the ideal what we call protection that should be provided by the nation states in their backyard or in their country. But at regional level, my dear friends, there is a solace, there is a sense of satisfaction. Because at a regional level, I feel this is the most remarkable journey undertaken under the mandate or under the auspices of the African Union. At least the African nation states understood this particular necessity, and this necessity is away from the imperial forces and imperial what we call understanding or the globalized understanding, and they came out in a decolonized fashion. They came out with a regional arrangement for the protection of internally displaced persons. And it is basically known as, my dear friends, the 2009 African Convention on Internal Displacement, which is sometimes, since it has been concluded in a city called Kampala, so it is also known as the Kampala Convention. So 2009 African Convention exclusively meant for entire Africa continent. They came out with the Kampala Convention exclusively devoted to internally displaced persons. So that is another important dimension that must also be taken care of in this connection. When we are talking of internally displaced persons, though recently we have also came out in our book that is on climate refugees, we have also designed and coined a new word with regard to the what we call environmental displacement or climate change induced displacement as climatically displaced persons. And these climatically displaced persons are not at all supposed to cross international borders. Then there is another important terminology which we are going to address in this engagement, my dear friends, and that will occur or likely to occur on many occasions, that is known as the economic migrant. Economic migrant is someone, my dear friends, who leaves his or her country of origin purely for financial and economic reasons. Therefore, economic migrants, my dear friends, choose to move in order to find a better life, and they do not, flee because of any kind of, persecution or the ground or many other grounds of, persecution. Therefore, they do not fall within the criteria for refugee status and are not entitled to receive international protection. Because the economic migrants move and leave their country voluntarily, and because of the upliftment of their economic conditions for greener pasture, they go. Another important term, that is EXCOM in an abbreviated form, Executive Committee, which is in abbreviation known as EXCOM. There are certain important, EXCOM resolutions, EXCOM, comments, ESCOM observations, which on many occasions have also provided some kind of a beautiful guidance for the resolution of specific refugee problems. So we also use this ESCOM. ESCOM, therefore, ESCOM, particularly the Executive Committee of the United Nations High Commissioner for Refugees, is entrusted with the responsibility of advising the High Commissioner for Refugees on the exercise of his or her, functions, powers, and duties, reviewing and approving the agency's programs and budget, counseling further on international, what we call, protection refugees, relating to refugees, relating to asylum seekers, stateless people, and though stateless people are not generally the direct what we call mandate, but there are what we call some specific international conventions on stateless people. This reminds me of a very, very important convention of 1954, UN Convention on Statelessness. Another important convention is also there, that is 1961, United Nations Convention on the Reduction of Statelessness. So there, these are the two important arrangements, along with a host of what we call of human rights treaty obligations. So that is another important. Irregular immigrant resettlement and other important what we call understandings are also there. So there are many important terms, my dear friends, and these terms under all circumstances must be what we call appreciated, along with other important frameworks. As I have already submitted, my dear friends, that there are certain important questions. These questions I have incorporated in the course structure. The first week course structure, therefore, my submission is you must study as a part of the course structure. I have also provided, my dear friends, the primary what we call text, primary sources as a part of your course structure. And this time you will also find well what we call adumbrated list of what we call these primary text as a part of your course structure. So my submission is you must go through it. Again, I have also provided certain important specific videos as a part of the course structure, and even prior to what we call first week, these videos start. You should also take care of them, and that is why if you are undertaking all these developments and understanding each and everything, then it would be very easy to understand the different what we call dynamics, dimensions of international what we call refugee law. So this is very, very important, and try to understand all these developments in this particular context. Now I invite your questions, and thereafter I would like to what we call proceed further on this on this issue of what we call of further engaging you on the aspects of what we call of of any other question. Any observation?
Hello.
Put. Yes, Miss Karishma.
Yes, sir. Sir, I had a question. I think so it's something related to terminology or the definition of refugee. So I wanted to ask, what comes first? Like, does asylum seeker come first, or refugee? Like, if a person is he a asylum seeker first, then a refugee, or he is already a refugee and then is seeking asylum? Yes, sir.
A person who is fleeing persecution, right, has been, designated under international refugee law as a refugee. I must tell you at this stage, Ms. Karishma, first of all, it is a very important question. When ordinary law protection, when ordinary international law protection, when ordinary national law protection stops, then international refugee law starts. That is the, situation. International human rights law stops. International immigration law stops. International humanitarian law stops. International constitutional law stops. At the same time, on the point when these, legislations, conventions, and laws stops or stop, international refugee law begins. There are situations of individual fleeing persecution, a group of individual fleeing persecution, a racial community, ethnic community, a community of a particular membership or with a particular membership of a social origin, they flee persecution. So they are basically determined, their status is determined as a refugee at the border. When the mass exodus of refugees is taking place, and a country A is receiving a mass influx of, refugees at its border, then en masse, first of all, they have to what you call accord protection. Because this is the beauty of international refugee law, that in situations of the determination of refugee status, no documents prima facie speaking, no documents, no travel papers, no passport, no visa requirements are necessary. They are immediately taken as refugees. At a second stage, at the subsequent stage, their antecedents and credentials are determined at the time of RSD, that is the refugee status determination. Then they are, singled out, they are sifted, they are separated. Who is a refugee, who is asylum seeker, who is a migrant, who is a, economic migrant. Because it has also been, witnessed in many situations that even criminals, convicts, army deserters, radical elements, militants, terrorists, they have also become the part of what we call the mass exodus of refugees, and they infiltrated in the country of reception. So a lot of, dimensions are involved. So first of all, a refugee prima facie understanding is a person who happens to be or fleeing persecution is considered as a refugee. It is generally identified at the time of what we call of the individual status determination of his or her refuginess. So this is how the refugee status is, determined. Sometimes refugee status is determined by the national what we call, authorities of the country of reception. Sometimes United Nations High Commissioner for Refugees determines. in a particular, country, whose government or that country has become party to 1951 convention, or sometimes both the, state of reception as well as, or state of destination as well as United Nations High Commissioner for Refugees, both, determine a refugee status. They collaborate. Collectively, they conduct a refugee status determination exercise. Anything else? Any other observation? Mr. Sagar Verma, are you there?
Yes, sir.
Anything else, brother? You are keeping mum?
No, sir.
Everything all right?
Sorry, sir. I'm not able to hear you.
Are you okay? Your voice
Yes,
is
sir. I'm fine. Yeah,
okay.
I'm little bit feeling down today.
Okay, because it is, visible in your voice.
Yeah,
And
yeah, yeah.
please take care of
Yes,
your health. It's very
yes, sir.
important. Yeah. So,
Yeah.
let us have a prima facie understanding. My dear friends, international refugee law, particularly international refugee law scholarship, has long been, dominated by a positivist tradition within which the human rights based approach that is popularly known as HRBA has now become the dominant approach. However, states and their formal agreements get us only so far in explaining how refugee law is created and how it is developed. There is another what we call, layer of explanation that looks into transnational activities and their effect on how law is shaped, interpreted, formulated, applied, and developed. Therefore, there are two further what we call, emerging approaches in international refugee law. If we are at all interested in understanding what exactly are the contours of international refugee law, then there are two important approaches: transnational approach and participatory approach. My dear friends, it has been argued that the dominant human rights approach focuses mainly on sources and contents of rules. Of course, with their enforcement, both the transnational and participatory approaches are useful in capturing the complexities of the process of law formation and law development by looking more what we call specifically at networks and other participants in the process of what we call of international refugee law making. The challenge of the contemporary international refugee law, therefore, is to recognize more explicitly the role of the such networks and the soft law and norms that they generally often what we call produce. My dear friends, the movement of more than 100 million refugees by the end of 2022 across the world brought long needed attention to the inadequacy of the global humanitarian system. If you take into account, as I have submitted at the very threshold of my today's submissions, there are as many as, my dear friends, around 1 point. No, Balki, I should say 100.3 or 4 what we call million refugees worldwide. Therefore, international regime governing the receptions and the treatment of refugees, what in place at the end of the so-called World War II. Why I'm saying the so-called World War II? Because I call it the Europe War II. Therefore, there is a question which I generally put. Does it remain fit for the purpose? Peoples have been challenging its efficacy. If there happens to be tomorrow the Third World War, will it be a war sponsored by the global, what you call, South nation states? Again, it is going to be a war likely to be, imposed, or likely to be what you call, as a, manifestations of the ambitions of the global North nation states for their, what you call, supremacy over each other. If you take into account, my dear friends, the chaotic and tragic images of the Syrians fleeing across the Aegean Sea are what we call, repeated on the other side of the world. As the Rohingya refugees from Myanmar flee across the Indian Ocean, in both cases, and many more what we call, situations, states avoid orderly receptions and resettlement plans for the refugees and show little what we call, solidarity with first asylum, countries. How can states be what we call, convinced to cooperate to provide the protection all agree is necessary, rather than compete to impose over harsher what we call, barriers to entry? There cannot be any kind of a unanimity on these, cases. If you take into account the latest example from Ukraine, Ukrainian refugees have been received in the neighboring countries, but only those Ukrainian refugees who were having the white complexion. The refugees in Ukraine of the African descent or Asian descent have not been welcomed. Racial discrimination happens to be at the forefront. Even the European nation states in the Ukrainian and Russian Federation, what we call, military conflict, adopted a racially induced what we call, discriminatory practice. International digital platforms are replete with these kinds of news items that, again, European nation states have shown, registered their double standards in the refugee treatment. These double standards have been shown even by the original members who have been at the forefront in what we call, crafting 1951 United Nations conventions relating to the status of refugees. They turn out to be the biggest violators. What they have, promulgated, I mean, their own making was violated in the form of what we call, international conventions. As the number of what we call, refugees, asylum seekers, migrants, and stateless, in abbreviated form, I call them RAMs, and other, displaced people reached a level of not witnessed since the so-called World War II, the need for few approaches become what we call, indispensable. Worldwide sense of crisis, my dear friends, gave rise to an extraordinary series of international, conferences and meetings to specifically address the movement of what we call, refugees, asylum seekers, migrants, and stateless people. These international events have produced some practical, concrete outcomes, such as new what we call funding for humanitarian relief, locating new resettlement plans for refugees, and evolving new approaches to development projects that include what we call RAMS people. They also produced, my dear friends, and promoted broader rethinking of the relationship between development, mobility, and protection. As I have already mentioned, my dear friends, the 2016 New York UN declaration that has been the outcome of the UN summit. UN summit set out a broad set of commitments on responsibility sharing, protection of refugees, and orderly and the safe migration. The translating these commitments into reality presents a major challenge for the international cooperation, international what we call solidarity with the refugee hosting countries. If you take into account, as I have submitted at the beginning of my observations, we cannot simply deny the historical roots of the population movements. Therefore, it is mandatory at this stage, my dear friends, to have a retrospective understanding of the refugee movements or the population movements. Therefore, the United Nations organization and its humanitarian partners are under increasing pressure to meet protection needs the world's conflict zones, despite growing what we call threats to the security of aid workers and the constraints which are generally confronted in accessing populations who are directly in need of what we call protection, food, healthcare, and other important what we call necessities for the survival of a dignified existence as a human being on this beautiful planet. That is a necessity. Individual liberty, my dear friends. Individual liberty, individual dignity has been portrayed as one of the great moral achievements of capitalism. And that is in contrast with earlier societies where liberty was restricted by traditional bondage and servitude. But on a personal note, my dear friends, I do not concur with it. Individual liberty does not mean that some individual or one individual be allowed to burn the Holy Quran as a part of the freedom of speech and expression coming from a civilized European nation state. So I don't know, in the first quarter of the 21st century, what has become the criteria to determine individual liberty in European schematization. European so-called civilized European schematization. So we have to what we call ponder over. Even all the constitutions of the world, including South Asian constitutions, they came out with certain important red lines in their constitutions. And these red lines are known as restrictions, conditions, demarcations, derogations, limitations, constitutionalism, liberalism. Even Article 19, since charity begins at home, let me quote Article 19 of a very, very important and oldest constitutional document in South Asia, the Constitution of India. Article 19, subclause 1, contemplates as many as 8 red lines in exercising our free speech and freedom of speech and expression. That is why, my dear friends, the European orientation of the freedom of speech and expression is a colonized one. It is an exclusive what we call, it is, the freedom of speech and expression orientation of a European motive in Europe suffers from the syndrome of exclusivity. It suffers from racism. It suffers from xenophobia. That is why we require a separate kind of what we call of individual liberty. That determines and that should not be what we call inimical to the idea of refugeehood. our orientation of the refugeehood based on what we call, equality. The substantive and normative equality we propose. And that is why, my dear friends, we must, come out with an international convention collectively sponsored by the global South nation states. Because the individual liberty that has been what we call, propagated and promoted by the global North nation states suffers from racism and the white, supremacy. It got nothing to do with the idea of, dignity, equality, and fraternity. These are not the, fundamental principles of their what we call orientation. See the entire what we call, globalization. See the making of the so-called international institutions like United Nations Organization, like WTO, like other what we call international multilateral organizations. All have been, hijacked and dominated by this kind of what we call, thinking. That is why we should come out with our own, orientations. And I'm happy that except Afghanistan, no South Asian nation state is a party to 1951 conventions relating to the status of refugees. I find more solace in the African what we call, convention of 69, that is governing the specific aspects of, refugees. That is more what we call, more, conforming to our, aspirations, to our, ideals, ideas of the, institution of the refugee protection or our understanding of the refugeehood. I can appreciate a formal soft law in Latin American countries, which is popularly known as 1984 Cartagena Declaration. Over the years, my dear friends, all the national legislations on refugees in Latin American countries have reflected upon and they have incorporated the normative fundamental principles of this declaration in their own what we call hard laws, national legislations. It is altogether a different story that after so many years, professors like Professor B.S. Chimney, who is currently the part of the Jindal Global Law School, after retiring from Jawaharlal Nehru University, now he has also started advocating that the India must ratify 1951 UN Convention relating to the status of refugees. But if you take into account his entire what we call magnum opus, which he has produced in the area of international refugee law, he has always been in the camp of what we call of opposition. He always opposed any kind of a ratification of 1951 convention relating to the status of refugees, but now he has started. And this what we call, change. The catalyst of this, change, I think in my understanding has been that can be attributed to the adoptions of the global compacts on refugees and migrants under the mandate of what we call of 2016 New York Declaration on Refugees and Migrants. So this is a very, very important deviation from a position that was maintained for the last more than 35 years by such scholars. So in this kind of a scenario, what kind of a institutional structural framework should be there for the protection of what we call of refugees? Is it the meaning of individual liberty? What kind of a threshold of civility has been there? Therefore, my dear friends, in the post 1945, migrations may be new in scale and scope, but population movements in reaction to demographic growth, climate change, and the development of what we call of production and trade have always been part of the human history, but without any kind of a civility. Slave trade has always been promoted by the Western nation states. The Red Indians, communities in Australia, in what we call in United States of America, or many geopolitical entities of Europe, are nothing but the what we call violations of human dignity in the name of what we call of human civilization or civility, so-called civility. Europe, or rather I should say, global North nation states, on a personal note, I feel this geopolitical arena has always been the heart of darkness. In their perception, in the European and American what we call perceptions, we, the people hailing from the global south, have been the heart of darkness. Scholars like Joseph Conrad, who has written a novel, Heart of Darkness, in praise of what we call the Western civilization, is nothing but the what we call resulting into the heart of darkness in European nation states. That is why, my dear friends, the time has come to have some kind of a de-Westernization, decolonization of education. Higher studies, what we call should be decolonized. Higher education research, institutions like what we call South Asian University, JNU and other institutions, educational institutions in South Asia must be decolonized in terms of our research endeavors and research projects. So there is a need to have, if at all we are going to have some kind of a regional arrangement for the protection of refugees, it must be a decolonized initiative. Warfare, conquest, formation of nations, and the emergence of states and empires have all led to migrations, both voluntarily and forced one. If you try to cajole the factors who have been responsible for all this kind of a miasma, you will find it was basically the enslavement and deportation of the conquered people. It was not only limited to the drain of wealth, exploitation of the natural resources of our what we call soil. It was not only limited to pulverizing our natural resources and other what we call wherewithal. Even the people have also been enslaved, and ultimately they have established a new kind of a what we call enslavement, which is known as the form of labor migration. So that is another important dimension to it. From the end of the Middle Ages, my dear friends, the development of European states and their colonization of the rest of the world gave a new impetus to international migration of many different what we call shades and kinds. In Western Europe, migration was a long-standing and important facet of social life and the political economy from about 1650 onwards, playing a vital role in the modernizations and industrializations of the European economies. And that is why I call them as parasite economies. The denial of the role of immigration in nation building has been crucial to the creation of the myth of the national homogeneity. The devastating effects of the international migration on the indigenous peoples of the colonized countries have been, unmatchable, I should say. The European conquest of what we call Africa, Asia, America, Oceania led ultimately either to the domination and exploitation of the native peoples or the genocide, both physical and cultural. Nation building, particularly, my dear friends, in the Americas and the Oceania, are based on the importation of the new populations. And we have enriched what we call, their populations and their understandings. So that is another important dimension. And first of all, we should try to understand what is colonialism. European colonialism pandered to various types of migration, my dear friends. The large what we call outward movements from Europe, first to Africa and Asia, then to Americas, and later to Oceania. Europeans migrated either permanently or temporarily as sailors, soldiers, farmers, traders, priests, and administrators. Around half of the soldiers and the sailors of the Dutch East India Company in the 17th and 18th centuries were not Dutch, but what we call, trans migrants, mainly from poor nations or the poor areas, particularly like, Germany, in the rural areas of, Germany. And in the later half of the 19th century, my dear friends, slaves were replaced by indentured workers as the main source of, plantation labor in many European nation states. Indenture, my dear friends, you can understand it's like a kind of a police system involved in the recruitment of the large groups of workers, sometimes by force, and their what we call transportations to another area for work. So this kind of a indentured what we call labor force was created. British colonial authorities recruited workers from the Indian subcontinent for the sugar plantations of Trinidad, Tobago, British Guyana, and other Caribbean what we call nation states or countries. Indentured workers were used in 40 countries, as many as 40 countries, by all the major colonial powers. Indentured workers were bound by street labor, very, very intransigent labor contracts for a period of, several years. Indentured workers were bound by with other so many what we call trappings, because indentured workers were always been fruitful. They have been considered, and they were often very cheaper for their employers than the slaves. And on the other hand, work overseas offered an opportunity to escape poverty and repressive situation such as the Indian caste system. So that caste system has also played a very, very important and vital role in pandering to or in facilitating indentured workforce or emergence of the indentured workers. Many workers remained as free settlers in East Africa, the Caribbean, Fiji, and in many other important geopolitical areas where they could obtain land or set up businesses. Indentures epitomized, my dear friends, the principle of divide and rule, and a number of post-colonial conflicts. For example, hostility against Indians in Africa and Fiji, and against Chinese in Southeast Asia, have their roots in such kind of a what we call of divisions. So therefore, history of what we call of population movements, my dear friends, we are having different kind of stages. Stage number one, my dear friends, if you name, industrialization and migration to North America and Oceania before 1940. That is one important stage. Second stage comes to labor migration within Europe, And the third stage, my dear friends, interwar period. I mean the period between the First World War and Second World War. What kind of a labor migration, enslavement, migration, indentured what you call labor workforce. What kind of a migration has taken place between the interwar period. That is the third stage. The fourth stage, my dear friends, constitute the migration in the age of the global economic rearrangement. And then the contemporary trends of migration. This is the almost fifth important stage of our understanding. So far the migration is concerned. So these stages are concerned. I will further what you call elaborate it, and we would be further deliberating the history of what we call protection of refugees. What has been the historical roots? What has been the etiological understandings of the idea of protection, and what has been the contributions of various what we call factors, including the nation states from our part of the world, in enriching this particular history, and how we should try to understand this particular history of population movements. I will continue. Any questions? Any observation? So please read the material which I have already shared. And by tomorrow evening, I would also share a few important books. That is one announcement. My next submission is the day after tomorrow on 25th. I will also conduct an online meeting with all my dissertation students. So by tomorrow, I will also share a link. It would be organized in the afternoon. So in advance, I am informing you. So please prepare your questions, whatever the questions you are having, number one. Number two, whatever the feedback you got from the faculty collective at the time of presentations of your LLM dissertation synopsis. Number third, if any student is of the view, though he is not under my supervision, but if any student is willing to have some kind of a discussion, he may also join, and he may, I mean, my students, my LLM dissertation students can also share the link with that very student. Or otherwise, you can also approach me directly, write an email today. So I will include your email as well in the online meeting on dissertation on Wednesday, day after tomorrow in the afternoon. So thank you very much. If you have any questions, you're most welcome. Yeah, Mr. Shivank, would you like to have any observation, any question?
So not today. I'll just read the material and ask you maybe tomorrow.
Yeah, most welcome, please. So please, one more, submission, and that is a very important one. Please do care of your health. Maintain your health. Observe each and everything, because we are going to have a weather transition. So please be careful about your health. Yeah, thank you very much. Wish you all the best. Enjoy yourself. The day is still young. Bye-bye.
Thank you, sir.
Take care.
Thank
You're
you,
welcome.
sir.
Thank you, sir.
You're welcome. Thank you. Thank you.